Welcome back, folks. You're watching Law and Crime live on the Crime and Investigation Network. We're going to take a pause from the Tex McIver case to talk about another case that's in the headlines today. That's the case of Adnan Syed. He was the subject of the first season of the podcast Serial. He was convicted of killing his former girlfriend, who was 18 years old, when they were in high school. Now, an appeals court in Maryland has just decided that Adnan Syed should get a new trial. This is an intermediate appeals court, so it could go back up the chain even further. It could go back to a new trial. Attorney Justin Brown has been handling the appeal on behalf of the defendant. Justin Brown joins us live on the Law and Crime Network. Justin, good to see you.
Thanks for having me.
Okay, so let's break down this decision. This is a decision that basically agrees with your presumption that this defendant had ineffective assistance of counsel. Now, specifically, there was another witness who apparently was ready to say that she saw your client, the defendant, in the library at the time the state said that he was committing a murder, and that the old attorney who handled the trial didn't call this witness. Now, if all of that's true, that's a huge detail. Not a surprise that your argument won, correct?
That's right, although interestingly, we lost on that issue at the circuit court, at the trial court level, and won on a different issue, on a cell tower issue. And what the appellate court has done has sort of flip-flopped the issues. The issue we lost on below, we just won, and the issue we won on below, they just reversed.
Okay, now your client has gotten a lot of attention because of the podcast and whatnot. Is that some of what spurred you to keep pushing this appeal forward?
It's definitely helped. One of the ways in which the podcast helped us was we had been unable to produce the alibi witness in court in Baltimore years earlier in the original post-conviction proceeding. And as Serial became, as it snowballed and became a national sensation, this particular witness caught wind of it, and only then did she understand how important she was to this whole case. And then she came forward, and then we were able to bring her into court to put her under oath and hear her testimony.
Now, that witness, Ms. McLean, she ultimately was going to say, hey, look, your client wasn't anywhere near the crime scene. He was in the library. But, you know, you've got other evidence against your client in this case that was strong enough to get the conviction. You've got the friend, Jay Wild, saying that your client showed the victim's body to him, and that Jay Wild, this key witness for the state, said that he helped your client bury the body. Now, should people be listening to Jay Wild, or should they be listening to the new witness, Ms. McLean?
Well, if they're going to listen to Jay Wild's, the first question they would have to decide is which of his stories are they going to listen to? He's told, by my count, 4 different stories to date. Even more recently, he gave an interview with an online publication in which he gave yet another story. And even critical points in his story have changed with time. He's run into his own, he's got his own problems as a witness. And what we have found, our conclusion, as well as if you read carefully the Court of Special Appeals opinion, is that he is a very problematic witness for the state. I think even the state would admit that, and indeed they did in the opening statements of the original trial. So sure, Jay Wilds is the best thing that the state has going for them, but he is a weak witness.
Now, the dissent to this decision, and I realize it's a dissent, but the dissent to the decision that came out today said that Asia McLean, the new witness that you'd like to put forward, may have her own issues as well, saying that maybe the original trial attorney had reason not to call her because there were questions about her own trustworthiness. I look at this and say, okay, well, the whole point of having a jury trial is to have the jury weigh the credibility of all the witnesses. And it seems that ultimately that's your goal here, correct?
That's absolutely right. The issue of how effective of a witness Asia McLean would have been is sort of secondary to the question of whether the trial attorney, you're a trial attorney, you're defending a murder, you have an alibi witness who it was with the defendant at the time when the crime was allegedly committed. What that trial attorney failed to do was even pick up the phone, call the alibi witness, and vet her story in any way. The trial attorney never even contacted Asia McClain, even though she had in her possession Asia McClain's phone number and a time when she could be reached at home. So that's what this is about. This is about a failure of the trial attorney to take very, very basic investigative steps in order to defend her client.
So have you had a chance to speak with your client? Is he looking forward to a new trial? Is he bracing for the possibility of another hop up to the highest court in your state, which could also be another outcome of this?
I did have the opportunity to speak to him. Obviously, he's very happy with the Court of Special Appeals ruling. We also know, and you know, he understands that this is not the end of the story. There could be another appeal. We hope that the state will see things the way we see it and say, hey, they're confident in their case, we're confident in our case, let's take it to a Baltimore City jury and see what they say.
Yes, and the jury will weigh the credibility of these witnesses. One who has told, in your words, what I think 4 stories, another one who police were afraid wasn't credible herself. That's for the jury to sort out. Attorney Brown, while I have you, I asked this question of many attorneys who join us. You concentrate on criminal appeals, as I understand it. Why do you like it so much? Why do you keep going?
I don't. Sometimes I like it, sometimes I don't. It's incredibly gratifying. You know, I think one of the fundamental problems with our legal system is this notion of finality, that our courts will bend over backwards and will do anything to avoid reviewing cases. They don't want to reopen cases. And unfortunately, that occurs even when there was an injustice or a constitutional violation in the underlying case, as you saw in this case, and as the Maryland courts have decided occurred in this case. They don't want to go back in and do the hard work of looking at it. Our job as an appellate lawyer or a post-conviction lawyer is to force them to do that and to be persistent and to keep fighting and digging and fighting and digging until finally they will open their eyes up and they will consider that maybe something went wrong in the original trial, because this kind of thing is more pervasive than most people realize.
Justin Brown, a big win in an appeals court today. Attorney for Adnan Syed, the subject of the podcast serial in its first season, who is possibly going to be getting a new trial if this is not appealed further. Attorney Brown, thanks a lot for joining us here on Law and Crime. Come back anytime.
Thanks for having me. My pleasure.
All right, we're going to continue our review of our analysis, I should say, of the Tex McIver case in Atlanta, Georgia. It looks like we've got another witness live on the stand there. Again, this is a case where an Atlanta attorney is accused of killing his CEO wife. The attorney, who's now a defendant, says it was an accident. Let's go back live to that courtroom.